Good day, Crime Talk aficionados. We have a great show for you today. First, I think we are moving forward with no continuances in the Bryan Kohberger matter, and I'll tell you why. The defense begins their case in chief in the Karen Reed case. I think it got off to kind of a bumpy start. Lori Vallow is going to try playing lawyer one more time. A founder of an orphanage for troubled youth gets sentenced for, guess. Wisconsin judge seeking dismissal of federal charges, citing judicial immunity. We have this day in legal history. Our legal quote of the day is about expert witnesses, since, well, that's what we're getting a lot of in the Karen Reed case. And then finally, our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we get started, I'm going to remind you to go to crimetalksearch.com. Sign up for that background subscription service, which you can cancel at any time. So you can do one search or you can do 1,000 searches of anyone here in the United States. And then you're going to be able to get a comprehensive report. And that report is going to provide information about the person that you're searching. For example, their social media history, emails associated with them, which could include social media history, maybe some you're not aware of. You're going to find out phone numbers that are associated with the person you're searching with. Why does your husband have that second phone that he says he never uses? It's his buddy's? Go check it out, right? And then on top of that, you're going to find out if they have a criminal history. Do they have liens, judgments? Are they on one of those sex offender registries? Yes, ladies and gentlemen, if someone is coming into your life and you're not sure about it, maybe not that warm, fuzzy feeling, or you think they're great, go check them out anyway. I'm telling you, when we do these searches, and we use this almost on a daily basis in our law firm, checking out witnesses, we always find something we didn't expect. So go to crimetalksearch.com. You're going to be happy that you did. All right, so let's go ahead and open the record for Friday, May 30th, 2025. Can you believe we are almost into June, ladies and gentlemen? All right, first on the docket, Bryan Kohberger. Now, you know, because we've told you, the defense has filed a 40-page motion to continue, citing every reason under the sun why they don't want to go to trial. And I think the judge has made up his mind. Now, remember, the judge has the motions for the alternate suspect. He's seen the motions filed. He's seen a lot of the evidence that the defense says that they haven't had enough time to review. And when pressed at the previous motions hearing, you know, Ms. Taylor basically said, well, Judge, I have to review everything. Well, no, you don't. This case isn't that complicated. Yes, there's so much digital evidence in this particular case. And that's why you have paralegals and you have associates that are going to go through all that information along with investigators and narrow it down to the really relevant stuff that you're supposed to be looking for. In today's modern litigation like that, with a case this size, there's no way an individual attorney could do it all himself. And the judge acknowledged that. Okay. And the prosecutors have noted that, 99% of it is not really relevant to the night in question. So the question, obviously, that we don't know the answer to yet, and, I hate to speculate, but I'm trying to use some years of experience here, that I think the continuance request by the defense is going to be denied. Why? Let me tell you why. The Judge Stephen Hippler, issued an order regarding juror questionnaires for the upcoming Bryan Kohberger trial. Now, just as the court did in the high-profile case of Lori Vallow and Chad Daybell, the Ada County District Court says it is summoning hundreds to thousands of people to their courthouse to fill out questionnaires. This will happen in the weeks before voir dire, and that's obviously where the jurors are questioned by the attorneys. So the Ada County Deputy Administrative District Judge Jim Cawthorn was asked questions about the process, which will be closed to the public and the jury selection in general. Now, the judge said that after people receive their summons, they'll be brought into the courthouse and will give instructions on how to fill out the questionnaires. They will have ample time to complete it before it's turned over to the jury commissioner. And then the judge, who did not say how long the documents will be, it is currently sealed under court orders. Now, these documents will be copied and sent to the defense, the prosecution, and the judge, and And from there, it'll be obvious that some jurors won't be able to sit on the panel as prospective jurors. The judge noted, he said that people that may be receiving those, that there's a lot of information attached to the summons, and those questionnaires they think will really be important for prospective jurors to pay attention to and actually read the questions, the kind of information that they need to know, but is also information they need to know about the participants in the particular trial. So when asked if the judge was concerned about pretrial publicity impacting the jury pool there in Ada County, he said he isn't. And what he meant by that is you don't want the type of pretrial publicity that makes the job that's much more difficult or adds concerns that you have in picking that jury. The judge said, am I concerned about the ability to find a jury that will be able to seat a jury? No. This is one in a series of many, whether it's just within this community or the state, that's highly publicized trial that they've had there in Ada County. It may be difficult to find potential jurors who have never heard of this case, but the judge said attorneys need to seat jurors who can be neutral. There's not a favoring the state. They're not favoring the defense. And, you have to have somebody who's going to be able to set aside whatever they thought about this case and say, I can decide it based solely on the evidence presented in the case and not be influenced by some outside factor. That's what the judge said, which we talk about all the time here on Crime Talk. You may have some knowledge generally about the subject matter, or, you've heard generally about what's on trial, or even hold an opinion that may run counter to what's the trial is going to be about, right? But the question is, can you base your decision solely on the evidence in the case and follow the law instructed by the court? That's the legal standard, ladies and gentlemen. You don't get a perfect jury. You don't get a jury that has been completely living under a rock, but you're going to find those people, particularly in larger jurisdictions, that just don't follow this type of news. And so it's not going to be impossible. They'll find a jury. They're going to be people say, yeah, I've heard about it, but I haven't followed it. And I'm willing to make my decision based upon the evidence that's presented in court, and I can follow the court's instructions. Those are the legal standards. So ultimately, 12 jurors will be selected, right? That's required. And 8 alternates will be seated in the Kohberger trial. Now, the judge also noted that the voir dire will begin on August 4th at the courthouse, following by opening statements, which will begin August 11th. Trial expected to last until November. So let's break this down. What this means is they're sending out summons so people can fill out these questionnaires, basically, make sure they have good contact information so they have them returned. The court is not going to inconvenience all of those people and go to the expense of sending out all of these summons for jury duty unless they're going. So I think that's one of the indicators why there's not going to be a continuance. All right. Now, what's going to happen? These people are going to come in. They're going to say, you've been selected. Please fill out the questionnaires, read it carefully. And you're going to find people that say, oh, yeah, Bryan Kohberger's guilty. Boom. All right. They're going to be a big stack. Everyone's going to get a big stack of juror questionnaires. And now remember, normally, if it wasn't a big case like this, you'd get your stack of juror questionnaires. Sometimes maybe it's a page or two long at the most, and you get 20 minutes to go through all of the potential juror questionnaires. Here, the defense, the prosecution are going to have more than sufficient time to do that. And they're going to go through, and when they say, I can't be fair and impartial to the prosecution, or the defendant is absolutely guilty, guess what? They're just going to strike those people and say, you don't need to come back. Have a wonderful day. Hope you never need a jury in your life someday, right? So that'll take place. Then they're going to whittle that down to ultimately where they get probably 70 some odd people that are going to be kind of the presumptive panel. They'll put them in, they'll do voir dire, and then they'll go through the process ultimately to do that. But there's going to be a lot of individual questioning of these people based upon these questionnaires. They're going to say, well, they didn't really answer that question. Let's bring them in, talk to them in chambers or, outside the presence of everybody else. The defendant will be there, and then you get to hear. And sometimes, you'll develop a secret method. For example, when you go into you go in the back room for chambers when you're talking to jurors, the judge will oftentimes say, all right, let's do the plastic cup method or the marker method. And what that means is when you start questioning that juror in chambers and they start making it very clear that this is not the right jury for them, instead of asking questions that everybody agrees, the defense will put out their little marker, the prosecution will then put out their little marker, and the judge will be like, all right, thank you, juror 126, we appreciate you. Why don't you step outside and we'll be more than happy to speak to you in just a minute. My clerk will be right out. And they'll say, all right, juror leaves, attorney, judge, and prosecutor are in there. And they say, all right, looks like we have an agreement for cause, right? Yes, no objection, boom. Judge then tells the clerk, go tell juror number 126 or whatever it was, have a nice day. Their service has ended. And so they'll do that with a lot of jurors in chambers. Obviously, not so much in murder cases. You usually do a lot of those in chamber type of issues on sex assault cases because people don't want to talk about that stuff openly, particularly if they've been a victim. And if you've ever been on a sex assault jury, man, I'm telling you, people have no idea. There are so many people out there that have been victims of some sort of sexual abuse, and sex assault trials are so difficult to get jurors because there's so many people that have never reported things, or they have reported things and they either receive justice or they don't receive what they believe to be justice. And so they're very, very difficult cases. Murder cases, not so much. Everybody wants to be in a murder case, right? Everybody wants to be in a murder case trial, jury. But when it's going to take 4 months, that's where it gets a little tough trying to find people, right? So what are we going to get? 12 people, good and true, otherwise unemployable generally. All right. So we're going to get probably older people. Don't think students are going to do it. It's going to be older people. So anyway, that's why I think we're going to have a trial in August. Also, a couple of recent filings, order sealing the exhibits attached to the state's supplemental rebuttal disclosure regarding penalty phase expert, Dr. Jason Gage, G-A-G. So apparently motions to seal exhibits to the state's supplemental rebuttal disclosure filed herein and no objection from the defense. The court does hereby confirm an order that be sealed. There's also an order as a part of the administrative process of this trial. Before voir dire begins, questionnaires will be distributed to and completed by jurors at the Ada County Courthouse in order to maximize the courtroom space and efficiency of this process. And because the distribution of questionnaires is an administrative function, observation of this process is limited to counsel and the defendant. What's the significance of that? It's dated May 28th, ladies and gentlemen, when that was done. So, or at least it was posted. It looks like it was signed at 9:27 in the morning, but it didn't get on the docket till yesterday afternoon for us to see it, or the court's website. So there you go. And then also interesting, a stipulation to excuse penalty phase witnesses from Idaho Rules of Evidence 615 exclusion during the guilt phase. So that is 615 is in regards to sequestration orders. Comes now the state of Idaho by and through the Latah County prosecuting attorney and the above named defendant by and through his undersigned attorney of record, and hereby stipulate, fancy word for agree, to the court's excusing witnesses who will only be testifying during the penalty phase of the trial herein from exclusion during the guilt phase under Rule 615. This applies only to contemplated penalty phase witnesses who are not also testifying during the guilt phase. What does that mean? Obviously, if they're a witness, then they should be excluded. But, for example, family members, things of like that nature that may testify for the defendant, but they've been endorsed, except for the family members. If they're only for penalty phase, then they can sit through the trial and go from there. And then once again, order sealing state's proposed supplemental jury instructions. We've talked about this, ladies and gentlemen. Jury instructions have become normal and routine. If there was a homicide case, I could go back here to these books right back here, and I could pull out all the necessary instructions that we need, and they're right there. There's nothing secretive about jury instructions. I don't understand why jury instructions are being ordered sealed. It doesn't make any sense. Anyway, Idaho, you guys do things a little differently out there. I appreciate that, but it doesn't make any sense to me why jury instructions, particularly as it relates to the elements and what jurors need to follow the law for, would be of any secrecy whatsoever. All right, let's move on. Next on the docket, Karen Reed, day 24. The defense begins their case in chief with an accident reconstruction expert. So today, the Karen Reed murder trial entered its 24th day of testimony at the courthouse there in Massachusetts. Now, following the prosecution resting its case late Thursday afternoon, the defense called its first witness, accident reconstruction expert Matthew D. Sogra, marking a pivotal moment in the high-profile case. Now, the judge noted that the trial is progressing ahead of schedule, with the defense estimating that their case will take approximately 1.5 to 2 weeks to present. Now, let's give you a little recap of what took place today. Now, first, for those who don't know, Karen Reed is charged with second-degree murder, manslaughter, and operating a motor vehicle under the influence and leaving the scene of a fatal collision in connection with the death of her boyfriend, Boston police officer John O'Keefe, back on January 29th of 2022. Prosecutors allege that Reed struck O'Keefe with her Lexus SUV during a snowstorm outside of a house party at 34 Fairview Road in Canton, Massachusetts, after a night of drinking, and then left him to die in the snow. Now, Miss Reed has pled not guilty, and her defense team contends that she has been framed as part of a vast law enforcement conspiracy, asserting that Mr. O'Keefe was actually beaten inside the home and possibly attacked by a dog, and then left outside. The first trial back in 2024 ended in a mistrial due to a hung jury, leading to the current retrial. So, what took place first thing this morning? The court convened about 9:13. The judge addressed the attorneys at a sidebar and requested, and then the jury was expected to enter the courtroom about 9:30. And then the defense made their motion for dismissal. Now, before the jury was seated, obviously, defense attorney Alan Jackson argued for a required finding of not guilty, a standard motion following the prosecution's case seeking dismissal of all charges against Miss Reed. Now, Jackson asserted that the prosecution has failed to prove that a collision occurred at 34 Fairview Road on January 29, 2022, citing the absence of an eyewitness, video, audio, or any definitive physical evidence linking Reed's SUV to O'Keefe's death. He described the prosecution evidence as nothing but circumstantial technical data and argued that no reasonable jury could find Karen Reed guilty, calling the case a vindictive prosecution. Anyway, Special Prosecutor Hank Brennan countered, highlighting scientific data and Reed's own statements about possibly clipping or hitting Mr. O'Keefe as evidence of intoxication as well, and the collision. The judge promptly and appropriately denied the motion, allowing the case to proceed. Ladies and gentlemen, this is a motion for judgment of acquittal, pursuant to Rule 27. All right? And bottom line is, they're routinely denied unless the prosecution has failed to present any evidence of any one of the elements in the charging documents. They've done that. Okay. Now, I told you, first trial through, I would have found her not guilty. Prosecutors were so bad. This time, though, and I've told you, because it's a retrial, prosecution usually does better because they fixed it. And the prosecutors knew that they sucked last time, so they brought in a hired gun. And what do you do if you want to get something done right? You bring in a defense attorney. And what defense attorney they did. Now, he was a former prosecutor. Like, I was a former prosecutor for a little bit, but been a defense attorney for the most of my time, right? You want something done right, you hire a criminal defense attorney to do it. And I would say that Mr. Brennan, the special prosecutor, has basically chipped away, if not meticulously chipped away, at the defense case in chief that they presented the first time through. And they're going to be a tough position to change their theory this time through. And we'll talk about that more in a minute. But anyway, the legal standard is that the judge must view the evidence in the light most favorable to the prosecution, drawing all inferences in their favor. The case was not going to get dismissed. And Jackson knew it. Reed knew it. Maybe deep down in little places where, Miss Reed's little heart beats right there, she thought there was a chance that it was going to get dismissed. No, denied. Okay. And I've been following some of these people on Twitter, or X, I guess now, right? And there's the Karen Reed is absolutely innocent, is pure as a driven snow, can do nothing wrong crowd. And then there's the Karen Reed is guilty, let's just get a rope crowd, okay? I'm trying to be objective, but they've presented the case much, much better than they did the first time through. That's the prosecution, okay? But I tell you, the crowd that Karen Reed can do no wrong, I want them on every one of my jury panels in the future. Okay. No matter what the prosecution presents, it's not good enough. Okay. Now, I know the Karen Reed can do no wrong crowd is saying, those experiments are ridiculous. They show nothing. Yes, they do. The data, as Karen Reed has said in her own words, is the data. And it clearly shows that she was backing up. They haven't disputed the data. Even their first witness, we'll talk about in a second. I mean, he's not really disputing maybe a little bit of the process, but that's it. Anyway, case is moving forward. We'll see what the defense is going to have to do. Now, the defense never has to present any evidence. And here's what I throw out to the Karen Reed crowd, that she can do no wrong and she's absolutely innocent. If the defense thought that the prosecution case was so weak, had no sway whatsoever with a jury, you can get up and say, Your Honor, the defense rests. Let's go straight to closing arguments, right? Because they have failed to prove their case beyond a reasonable doubt. And I'm telling you, as a defense attorney, I've won more cases when you keep your mouth shut, you focus on their evidence or the lack thereof, and you argue it in closing saying it's insufficient. The case that I just did 3 weeks ago, whatever it was, Grand Junction, drug conspiracy, wiretaps, co-defendant testifying, brutal cross-examination, kept out a lot of the evidence that they thought they were going to win because they couldn't lay the appropriate foundations. Get up, ladies and gentlemen, defense rests. Let's go to closing arguments. Boom, not guilty. Not guilty. Okay? I'm telling you, defense cases in chief, normally bad. Normally bad. If the prosecution's case is so weak, you present nothing, and that's what you argue. Because the burden's always on the prosecution. But once the defense starts putting up witnesses, then they start thinking, well, do I really believe that guy too, right? Before it was like, well, I didn't, maybe some of his stuff, the good points on cross-examination. And particularly if a defendant testifies, and we've already heard Karen Reed testify by her statements saying, I hit him. I went to my attorney and he said if I did clip him, I would have some exposure. Can you believe that? An attorney let her talk on tape about attorney-client communications? Ugh. I've always said it's the defendant's own words that are going to get her, okay? And I'm telling you, that's the case. And I would say it is malpractice to have your client, while your case is pending, giving interviews and statements about the case, because anything you say will be used against you. And Reed knows, or Brennan knows that, and he is utilizing it. Anyway, let's move on. So the prosecution has a motion then to limit some testimony. The prosecution filed a motion to preclude the defense from calling 4 witnesses related to some text messages from former Massachusetts State Police Trooper Michael Proctor. He was the lead investigator in the case, who was fired after admitting to sending some inappropriate, offensive texts about Reed during the first trial. Now, the motion argued that the defense seeks to introduce a limited portion of 38,707 text messages from Proctor's phone, from his phone, and exchanges in October of 2021 through August 31st of 2022, involving 9 individuals. Now, the prosecution contends that these messages constitute hearsay upon hearsay and require judicial review for relevance and admissibility. The issue set the stage for later testimony involving Proctor's friend, Jonathan Diamandis. Anyway, the defense then calls its first witness about 9:45 today, Matthew DeSogra. Now, the defense called this witness a licensed professional engineer at Delta 5 Forensic Engineering, specializing in accident reconstruction and vehicle data analysis, particularly event data recorders, or EDRs. Now, the defense attorney, Alan Jackson, who hasn't really been very involved lately, began by establishing the expert's credentials, including his degrees, professional experiences, his membership committee, and any courses that he's taught on vehicle data interpretation. Standard stuff you do to get the expert qualified as an expert. Look how smart he is, right? DeSogra was tasked with reviewing reports by the prosecution expert, Shannon Burgess, as well as Judson Welcher from Aperture LLC, who analyzed data from Reed's Lexus SUV and O'Keefe's phone to support the prosecution's collision theory. DeSogra testified about a timing discrepancy in Aperture's reports, focusing on how they referenced data from the end of the text stream event, a vehicle data recording triggered by a specific action, rather than the trigger point itself. He explained that a text stream event captures 5 seconds of data before and after the trigger event, totaling a 10-second window. By referencing the end of the event, Aperture's calculations introduced an approximate 5-second differential, affecting the timeline of events. Now, the expert then noted that the discrepancies created a 31-second window from the trigger event to 12:32:09 a.m. on January 29th, 2022. Multiple prosecution objections were sustained by the judge during this testimony, leading to a sidebar discussion. DeSogra then discussed differences between the Aperture's January 2025 and May 2025 reports, and in the initial report, Burgess identified 7 call logs from Reed's vehicle information system and O'Keefe's phone, but did not apply the timing offsets, resulting in a positive interaction window where O'Keefe's phone lock events occurred after the vehicle text stream event. In the amended report, Burgess introduced a 3-second timing adjustment based on testing with an exemplar Lexus SUV, creating a range of 9 possible outcomes. 5 where the phone lock occurred after the vehicle event, 1 simultaneously, and 3 before. This expert criticized the lack of testing on a second exemplar vehicle to validate the 3-second adjustment and noted that Burgess provided no data to prioritize one outcome over the others. Several prosecution objections were sustained, prompting yet another sidebar. Then the expert presented a PowerPoint, and I think this is funny because everybody made fun of the prosecution's experts using a PowerPoint. Well, he brought his own for the defense. Anyway, it was titled Analysis of Time from Reed, Lexus, and O'Keefe's Phone, entered into evidence and displayed in court. He highlighted a slide from Aperture's initial report stating that O'Keefe's last phone event, locking of the phone, occurred within approximately 26 seconds of the end of the text stream event, arguing it should say after. DeSogra emphasized that the phone and the vehicle clocks are unlikely to be perfectly aligned, supporting his finding that O'Keefe's phone interaction occurred after the vehicle event. He criticized Aperture's reliance on a single exemplar vehicle for a 3-second adjustment, noting that without testing Reed's specific SUV, the adjustment accuracy was uncertain. More objections from the prosecution were sustained, and then DeSogra continued to analyze Aperture's supplemental report, noting that the Burgess' new approach created a range of uncertainty with 9 possible timing scenarios, and he argued that the most valid method is to consider all data points rather than selecting a single outcome, accusing the Aperture's experts of inconsistent application of offsets. Can you imagine such a thing, to be accused of such a thing? Inconsistent application of offsets. How dare he? For example, applying a 19.2 second offset calculated by Burgess resulted in a positive 6-second interaction window, reinforcing that O'Keefe's phone lock occurred after the vehicle event. DeSogra's testimony faced repeated objections, many sustained, leading to yet another sidebar today. DeSogra then testified that the fairest approach to data analysis is to combine all available data to assess outcome comprehensively rather than focusing on a single point, as he claimed Aperture did. He reiterated that his analysis relied entirely on Aperture's reports and data. Additional objections from the prosecution were sustained, and the judge called yet again for another sidebar. DeSogra then testified that Reed's Lexus SUV had an airbag control module, a data recorder designed to capture collision events, but it showed no history of collisions included in the January 29th, 2022 event. He reviewed 19 text stream events from the 8 months prior to the incident, none of which were triggered by a collision, and the expert concluded that no data from Reed's vehicle indicate a collision occurred on the date in question. The prosecution objected to that line of questioning, leading to yet another sidebar. Now, the judge called a morning recess, requesting counsel to meet at a sidebar. During that break, to streamline later proceedings. Anyway, then they moved to the afternoon session. Cross-examination and voir dire took place. So after the recess, Special Prosecutor Hank Brennan began cross-examining DeSogra, challenging the scope of his expertise and analysis. And Brennan asked if The defense expert was asserting that Reed's Lexus never collided with O'Keefe on January 29th, 2022, and the defense expert clarified that he was not ruling out a collision entirely, but stating that the text stream events were triggered by a collision. So Brennan established that DeSogra is not an expert in mobile forensics, has not taken courses on information system variances, and did not conduct his own data polls or testing on Reed's SUV or an exemplar vehicle. DeSogra confirmed he relied solely on just critiquing Aperture's written reports, and Brennan also questioned why DeSogra's PowerPoint was submitted late on May 25th, to which DeSogra responded that he was asked to prepare it then. Anyway, apparently all the jurors seemed to be quite attentive during the cross-examination. I mean, what this witness testified to, we didn't think that there was a collision in the system. Well, they got that on cross-examination of their own experts. Now this guy says the defense's own expert says, although it wasn't recorded as this accident, I can't rule out that there was an actual collision with a human body. Sometimes less is more, ladies and gentlemen. Anyway, Brennan probed the expert about missing data in the infotainment system, referencing Burgess's successfully acquisition of the SD card. DeSogra clarified that his interaction window represented a range of 30 possible timing points and not a single moment. Brennan displayed a slide in court asking if it represented 10 seconds of data captured by a trigger, prompting an objection from Mr. Jackson and yet another sidebar. The judge then announced a 1-hour lunch break, allowing for jurors, obviously, to have their full lunch hour. Anyway, after the break, Brennan continued questioning the expert, focusing on the 3-second delay between the vehicle's power on event and the infotainment system's clock boot up as recorded by the SD card. DeSogra confirmed this delay was based on Aperture's data and called their analysis unique, questioning whether the 3-second adjustment was adequately accounted for. Brennan reiterated that DeSogra's opinions stemmed from Burgess and Weiker's report, emphasizing that DeSogra did not conduct any independent testing on his own. Brennan explored the clock variance between the vehicle's infotainment system and iPhones, noting that DeSogra was aware of calls logged on phones but not reflected in the infotainment system. DeSogra agreed that the clock variance can shift, affecting timing analysis, and Brennan pressed the expert on assumptions made in his analysis, suggesting that incorrect assumptions could alter his conclusion. The prosecutor then delved into the timing of the 3-point turn by Reed's Lexus, as documented in Mr. Burgess's report, which accounted for time variances after reviewing DeSogra's findings. Brennan's asked DeSogra if text stream data always captures collisions, referencing surveillance video from earlier in the trial showing Reed's SUV backing up into O'Keefe's vehicle in a driveway. And guess what? The expert for the defense acknowledged that some collisions might not register in the text stream data and said he did not recall seeing a collision in that time frame for that particular event. Brennan concluded his cross-examination focusing on the reliability of DeSogra's timing analysis. Then, of course, you got to get it redirect. So Jackson gets up, in his redirect, reemphasized that DeSogra was an expert in EDR data, not digital devices, and DeSogra has never misrepresented his credentials, and DeSogra filed an amended report in response to the Burgess's report. And that there was no technical events in Reed's SUV indicating a collision. Jackson posed a hypothetical. If O'Keefe's phone recorded 36 steps over 83 feet at 12:32 and 16 seconds in the morning, would it change DeSogra's analysis? DeSogra confirmed it would, as all 30 of his timing possibilities would show the phone interaction occurring after the vehicle event, further supporting the defense timeline. Brennan got to do a little recross, emphasizing that DeSogra's analysis relied on Aperture's data without any independent testing. DeSogra acknowledged that incorrect data would invalidate his conclusions, and after this back and forth between Brennan and Jackson, DeSogra's testimony concluded. The judge then released the jury for the day. Then we had to do a little testimony from Jonathan Diamandis, little voir dire of the witness outside the presence of the jury. The defense called Jonathan Diamandis, a childhood friend of Michael Proctor, for a voir dire to establish the admissibility of text messages involving Mr. Proctor. Now, the defense attorney, Mr. Yannetti in this particular particular case, questioned Diamante about his relationship with Proctor and his participation in a text chain with Proctor and other friends of over 30 years. Unnetti provided Diamante with a document containing text messages asking him to confirm the participants based on phone numbers and nicknames and to verify the authenticity of a message he sent. Diamante confirmed the chain's existence but did not delve into the message's context or the message content. Brennan briefly questioned Diamante, who was then released. Unnetti then continued his voir dire, asking the witness to review the text messages to establish the chain of participants' authenticity. The examination remained procedural, obviously avoiding message substance. Anyway, Diamante was quickly released after the Brennan follow-up. So there it is, ladies and gentlemen. Big takeaways, I guess. Matthew D. Sogra's testimony aimed to undermine the prosecution's collision theory by highlighting inconsistencies, what he believes the aperture's timing analysis, particularly this 3-second adjustment, and the lack of collision data in Reed's SUV, but by his own statements, not all collisions will be recorded. So that kind of hurt the defense. Anyway, they also used the defense also used DeSogra to challenge the prosecution's technical data, reinforcing their narrative that no collision occurred. But like I said, he conceded that that's a possibility. And then obviously Brennan sought to discredit DeSogra by emphasizing his lack of independent testing and reliance on, the prosecution's reports, while also addressing the prosecution's motion to limit testimony about Proctor's text messages. So that was it for the day, ladies and gentlemen. Frankly, I thought it was kind of off to a rough start. The defense was actually kind of shut down on lots of things. Lots of objections were sustained that were made by the prosecution as well. And hey, like I said, you Karen Reed people that thinks you can do no wrong, I want you on every one of my juries. You believe nothing. Nothing is evidence. Remember, people coming into court, testifying, and the jury hearing it, that is evidence, ladies and gentlemen. That's evidence. The jury can consider that. And if the case was so weak, why is the defense putting on their own case? We'll see. Give her the presumption of innocence. Like I said, I would have found her not guilty the first time because the case was presented so poorly. This time, I think she's got some problems. Next, let's talk about Lori Vallow. That's right. Lori Vallow was back in court yesterday. We told you about it yesterday. Motion to recuse the judge denied. And like I said, she's going to be representing herself at the trial in Arizona on charges that she conspired in an attempt to kill her ex-nephew-in-law. Now, the prosecutors down there in Arizona allege that Lori and her brother, Alex Cox, plan to kill Brandon Boudreaux in October of 2019. It's also alleged that Cox drove a Jeep that belonged to Lori's deceased husband, Charles Vallow, from Rexburg, Idaho to Gilbert, Arizona, then shot at Boudreaux outside of his home on October 2nd. Boudreaux was not injured in the incident. That's why they call it attempted murder. Anyway, at the time of the shooting, Boudreaux was recently separated from Lori's niece, Melanie Pulowski, and according to arrest affidavits, Lori and her fifth husband, Charles Daybell, along with Cox, told Pulowski that Boudreaux had some dark soul, dark energy when they allegedly began plotting his murder. Now, Boudreaux previously testified about the shooting during Chad Daybell's trial in Idaho, where he was convicted of 3 murders. If convicted of conspiracy to commit first-degree murder in the Boudreaux case, Ms. Vallow will face a potential sentence of life in prison. She's already awaiting another possible sentence of life in prison after an Arizona jury convicted her of conspiring to kill husband number 4, Charles Vallow. And the Arizona charges are obviously in addition to her life sentences in Idaho in 2023 when she was convicted of murdering her 2 youngest children, J.J. Vallow and Tylee Ryan, and conspiring to kill her 5th husband's first wife, Tammy Daybell. And Chad Daybell was convicted of the same charges, and, well, he got death. Ladies and gentlemen, what can you do? Next, founder of an orphanage gets sentenced. And can you guess what? Now, let's do the story and then I'll give my comment. All right. A 73-year-old Colorado man is going to spend the rest of his life behind bars for sexually abusing multiple children at an orphanage he founded and operated in Haiti. The U.S. Department of Justice announced that Michael Gallenfield received a sentence of 210 years in prison after a federal jury convicted him in February of one count of traveling in foreign commerce for the purpose of engaging in illicit sexual conduct and 6 counts of engaging in illicit sexual conduct in a foreign place between 2005 and 2010. According to the prosecutors, back in 1985, Gallenfeld, most recently of Littleton, Colorado, launched St. Joseph's Home for Boys, an orphanage for impoverished and otherwise vulnerable kids in Haiti. Well, the defendant reportedly operated the orphanage for more than 2 decades and would travel from the United States to Haiti, where prosecutors said he sexually abused the boys entrusted to his care. Many of the defendant's victims were under the age of 18 during the time of the abuse, and the defendant reportedly physically and emotionally abused the children in the home, including through physical assault and other forms of punishment. 6 victims testified during the trial, and they described the devastating impact that it had on them. Witnesses and victims also detailed manipulation tactics that the defendant employed to keep his operation running and financially supported by other people. Anyway, the assistant director of the FBI Criminal Investigation Division said for decades, Gallenfeld used positions of trust to exploit vulnerable children under the guise of humanitarian work. Wow, ladies and gentlemen, what do we say? How often have we said it? Oftentimes these people that want to do bad things put themselves in positions of authority so they make themselves look like the good guy, right? This guy, I'm going to go run an orphanage for troubled youths in Haiti, and I'm going to only have it for boys, right? So that when somebody makes an allegation, they go, how dare you question me? I am beyond reproach. I am a good human being. I am helping people, right? I am like Mother Teresa, something to that effect. And I hate to sound so cynical, but maybe that's what 30 years of criminal defense work will get you. Cynical. Because you see people that a lot of people think are good people, that they do really bad things, like this gentleman, Mr. Gallenfeld. So be careful. Be careful, ladies and gentlemen. Be careful who you let your kids around. Obviously, these kids were in an orphanage. They were completely taken advantage of. And Mr. Gallenfeld probably deserves the 210-year sentence that obviously he will never serve in its entirety because he will die long before that. Just be careful, ladies and gentlemen. Like I said, and I know there's good people out there. I know they are. But oftentimes it's just the guys to get to their victims. And, oftentimes people that are victims of sexual abuse, people will seek out people that, they don't have family, they're not supportive, and they're in a situation where they can abuse them and no one will do it. So this guy said, problem solved, right? I'll just open an orphanage for young men, coincidentally just their age. And not to get too sidetracked, but I had a case like this, ladies and gentlemen, years and years ago. I represented a guy, he was formerly a priest, inherited some money, left the priesthood, became a foster parent. He would only bring in young Hispanic males between the ages of 8 and 14. And he would show them all kinds of fun. And there were reports that they would run around naked. They would sit in the hot tub together. And then there were also allegations of sexual abuse. And it never, for years it didn't come out because he was such a good guy taking care of all these young kids in foster care. And then when the trial came about and they brought all these kids together who had never met, that had almost identical stories, that they were under his foster care. They would wake up in the middle of the night with this sharp pain in their, and it was the defendant. Maybe it's stuff like that that just makes me cynical, ladies and gentlemen. But I remember one of the jurors on the case, kind of a long thing, but there was already a pre-sentence report done. So the jury was convicted, or the jury convicted my client. We came back the next day for sentencing. And the juror was this construction worker guy. He goes, I would go home at night and I would just beat the hammer even harder, just thinking about your client, thinking what he did to those little boys. And he showed up you never know it's going to be good when the jurors show up for sentencing for a defendant. Never going to be good. Anyway, maybe that's why this job makes you a little cynical, but I know there's still good people out there. Let's talk about a judge in Wisconsin. A Wisconsin judge seeks dismissal of federal charges citing judicial immunity. So Milwaukee County Court Judge Hannah C. Dugan, charged with obstructing federal agents during an immigration enforcement operation, has moved to dismiss the federal obstruction charges against her. Her defense rests on the principle of judicial immunity, which she argues shields her from prosecution for actions taken in her official capacity, drawing a parallel to the broad immunity granted to the president for official acts. Now, for those who don't know, Judge Dugan was indicted following an incident in which she allegedly assisted an undocumented immigrant in evading federal officers after his appearance in a courtroom for a domestic abuse case. Now, the charges against her include obstruction of federal proceedings and concealing an individual to prevent their arrest, each carrying a potential penalty of up to 6 years in prison and a fine of $350,000. Anyway, Dugan has pled not guilty. She's given the presumption of innocence, and her trial is scheduled to begin on July 21st. But let's be clear. What the judge did was she found out that there were federal agents there to arrest this particular defendant was there. He had previously been arrested, been deported, and back in court for a domestic violence situation where the victim was in the courtroom. The prosecutor was there. Anyway, the judge took it upon herself to basically run cover and then, or to distract the agents, whereupon she escorted an attorney for the defendant and helped the defendant go out a back way, whereupon the officers had to then chase him down and arrest him, putting the ICE agents' life in jeopardy, at least according to the Department of Justice in their filings. Now, here's where it gets interesting. Yes, normally judicial immunity is for official acts. You know, things come in, you make decisions, you're wrong, it goes up to the appellate courts. They can't sue the judge for being wrong. All right? That's judicial immunity. But in this particular case, like I said, this judge didn't say, oh, I made a wrong decision or something, right? No, she didn't even call the defendant's case up in this particular case. There was victims waiting in the courtroom. The prosecutor didn't know what was going on. So basically, she told the guy to skip her own court appearance to avoid the federal agents. So it's going to be a factual issue as to whether that was a official judicial act. I somehow think once she steps off the bench and leads people down the back room of the courthouse, that's probably not an official act, ladies and gentlemen, by a judicial officer. Anyway, let's talk about it. So the theory of judicial immunity is articulated in Duggan's motion in a longstanding legal principle rooted in common law and reinforced by the United States Constitution, particularly the 10th Amendment, right? The dormant 10th Amendment. Everything not specifically mentioned in the Constitution is reserved to the states, which, like I said, reserves the power to the states, not delegated to the federal government. Anyway, judicial immunity protects judges from civil and criminal liability for actions taken within their official judicial duties, even if those actions are alleged to be malicious or corrupt. This doctrine ensures judicial independence, allowing judges to make decisions free from fear of personal liability or federal overreach. Well, Duggan's legal team cited the United States Supreme Court 1967 decision in Pearson v. Ray, which affirmed that judges are immune from liability of acts within their judicial discretion. The motion further draws on the 2024 Supreme Court ruling in Trump v. United States, which granted presidents absolute immunity for actions within their constitutional authority and presumption of immunity for acts at the outer perimeter of those official responsibilities. Duggan argues that judicial immunity is at least as broad as presidential immunity, protecting her from prosecution for actions taken in her courtroom. Now, Duggan's motion contends that her alleged actions helping the immigrant evade federal officers and informing agents they needed a judicial warrant fall within the scope of her official judicial duties. The argument hinges on the following point. Okay, absolute bar. Judicial immunity is not a defense to be evaluated at trial, but an absolute bar from prosecution. So they're basically saying dismiss the case in its entirety. And the motion asserts that the indictment itself is an ugly innovation that threatens federalism and judicial independence by allowing federal agents to dictate how a state judge manages their courtroom. Now, the Pearson ruling explicitly supports immunity for judges, even in cases of alleged misconduct, and was cited in Trump to justify presidential immunity. Now, Duggan's team argues that these cases confirm the judicial immunity extends to criminal liability for official acts, unless these acts clearly violate the individual constitutional liberties. So, the motion emphasizes that only conduct plainly well outside a judge's official duties lacks immunity. Duggan's actions, such as directing courtroom proceedings and questioning the authority of federal agents, are presented as falling within her judicial role, thus entitling her to immunity. the threat to federalism. The prosecution is framed as an overreach by federal authorities, undermining the separation of powers between the state and federal government, and the motion warns that allowing such charges to proceed could set a dangerous precedent where federal agents exert control over state judicial processes. Anyway, Duggan's legal team portrays the case as a significant threat to the principles of federalism and judicial independence, and they argue the prosecution reflects an attempt by federal authorities to encroach on state judicial authority. And a concern amplified by this involves the Immigration and Customs Enforcement in the underlying indictment. The motion paints a vivid picture of federal agents attempting to dictate the operations of state courtroom procedures and basically saying we're not going to stand for it. Basically, these agents were not interfering with the state proceedings. In fact, they were outside waiting on the bench, which is not uncommon. Now, lots of states and cities say you can't do that, but once they step foot outside of the courthouse, it's kind of fair. It's fair game. They can't go in and arrest him while he's sitting in the courtroom. That's not going to take place because it's a federal warrant. But hey, stranger things have happened. What can you do, ladies and gentlemen? It's going to be an interesting case. I'm torn on this, right? Judges are supposed to be impartial. Judges are supposed to call balls and strikes. If this gentleman had a federal detainer for removal, frankly, that far exceeds a county court judge's jurisdiction to get involved in. She should have called her case up, conducted her business, and let the man go about his way. And whether that was with the agents or not, that's the way it's supposed to go. This judge's own personal beliefs or opinions, well, then you need to take off the robe. And just because you're wearing your robe and doing something that really is outside the scope of your duties, why is she advocating for this defendant? He has attorneys to do that. I think she took off her judicial robe based upon the evidence that we have right now. We'll figure it out. We'll wait and see. Next on the docket, this day in legal history, May 30th, 1818, federal authorities in New Orleans were prosecuting pirates operating in the Gulf of Mexico under the Piracy Act of 1790, strengthening U.S. maritime law enforcement actions. And on this day in 1937, Chicago police killed 10 steelworkers during the Little Steel Strike, known as the Memorial Day Massacre. The incident led to legal investigations into police violence and strengthening labor laws. And on this day, on May 30th, 1950, Senator Estes Kefauver's committee was planning its investigation into organized crime, leading to televised hearings and the RICO Act of 1970. And on May 30th, 1977, the DOJ was finalizing Watergate-related prosecutions with convictions of Nixon's aides, prompting reforms in campaign finance and government ethics laws. And on May 30th, 1997, Timothy McVeigh's trial for the 1995 Oklahoma City bombing nearing its guilty verdict, reinforcing anti-terrorism laws like the 1996 Anti-Terrorism Act. Now, the McVeigh case is quite interesting because, well, I remember because it was here in Colorado and it was going on when I was in law school and I would go down and try to get in and watch it. But remember, that took place the bombing took place in 1995. The trial took place and was done in 1997. And I think there were some 280 victims in 2.5 years. So in 2 years, they were able to get that done. Now, they had Judge Mach, who was going to get that thing done. Probably one of the best U.S. District Court judges you ever did see. Anyway, he got that thing done. And like I said, 280 victims moved it along. Could you imagine in today's thing, they'd take that trial, it would take 10 years to get it done. Next, since we're talking about expert witnesses a lot today, how about a notable legal quote regarding expert witnesses from the United States Supreme Court case Daubert v. Merrill Dow Pharmaceuticals, a 1993 case where Justice Blackmun stated, "The inquiry envisioned by Rule 702 is, we emphasize, a flexible one. Its overarching subject is the scientific validity and thus the evidentiary relevance and reliability of the principles that underlie a proposed submission. The focus, of course, must be solely on principles of methodology, not on the conclusions that they generate." This quote underscores the court's role in evaluating the reliability and relevance of expert witness testimony, emphasizing the importance of sound methodology in their contributions to the legal proceedings. Methodology. Is it junk science? Did you just make it up on the stand? So I got a real problem with soft science, squishy experts like blind witness DV experts, blind witness sex assault experts. There's no methodology whatsoever. Anyway, I digress. And finally, our dumb criminal of the day. A Florida man's daring ferret caper leaves a pet land in shambles. Oh, look, another day, another genius Florida man pulling off the heist of the century. This time, our hero decided to liberate a $650 ferret from a Jacksonville pet land, because who needs wallets when you've got roomy shorts? The dazzling crime unfolded Tuesday afternoon, and let me tell you, it's the stuff of legend. Cameras, though pesky little snitches, caught this mastermind browsing the ferret section, probably whispering sweet nothing into the little furry's accomplice. Anyway, according to the police report, with flair for drama, noted that he fondled the ferret for quite some time. Truly a bonding moment for the ages. Then, in a move that screams, "I've planned this for weeks," he shoved the ferret down his shorts and sauntered out like auditioning for a low-budget action flick. As he made his grand exit, this criminal virtuoso was spotted clutching the crotch of his shorts because, ferrets need support during their great escape. He breezed past every point of sale without so much as making a concept of a payment. And a Petland manager, clearly not ready for the level of audacity, tried to chase him down but couldn't snag the license plates of the getaway vehicle. It's described as a white work van with multiple ladders along the top. And because nothing says untraceable like a van screaming, "I'm a contractor," but also a ferret thief. Anyway, our ferret bandit, a fashion icon in his blue Under Armour shirt and Navy logo shirt, sports a unique long mustache. And because if you're going to commit a crime this bold, you might as well look like you stepped out of a 1970s cop show. Sadly, the automated facial recognition system couldn't keep up with the sheer charisma, but fear not, those crystal clear surveillance images are basically begging for someone to shout out, "Hey, that's my cousin Dave." Here's to you, ferret bandit. May your mustache stay magnificent, and may your shorts always have room for one more weasel. That's all we have for today, ladies and gentlemen. I hope you enjoyed the show. Have a wonderful weekend. We'll see you next time. And remember, the Constitution matters.